Distinguished member from Maryland is recognized.
Thank you very much, Mr. Chairman, and
Morning.
good to see you again, Mr.
Good to see you,
Secretary.
Congressman.
I'm going to just briefly ask you a couple things about the H-2B, because coming to my attention that on March 4th, I guess it was the district court judge in Florida, struck down the ability of the Department of Labor to, I guess, issue rules and regulations, which in my mind would just return the DOL to the consultative role they played before 2008. Before the 2008 rule. So I've got to ask you, why in the world why didn't the department just return to the consultative role? Why did they shut down H-2B applications? You know, because you're from Maryland. I mean, that's devastating to my district. You know, closing down H-2B applications is devastating. And the first domino was DOL shut them down on March 4th, and then DHS shut them down March 5th because they can't do it without DOL, without the consultative role. What was the thinking behind the decision to just shut down applications instead of just returning to a consultative role?
Well, we're doing much more than just shutting down the program, Congressman.
You did shut down the program March 4th. Mr. Secretary, I'm right, though. The program right now is shut down.
We were told by a court that we lacked the authority to issue rulemaking and run the program. And so if we had
very specific. Why didn't you return to the consultative role that was present before 2008 and continue to allow the applications to be processed? It's a very simple question.
Because we don't have the authority to process applications if we don't have the authority to issue rulemaking or issue guidance. And so here is what we did do. We have been working very closely with the Department of Homeland Security. Last night, we filed a motion with the court with the approval or the lack of objection on the other side so that we can immediately get the order of the court stayed so that we can open the program back up. And we have made a commitment to have an interim final regulation in place by the end of April. I am acutely aware, having been the Labor Secretary in Maryland, of the importance of the H-2B program. I've had many conversations over many years with Senator Mikulski and others.
I'm limited to 5 minutes here. So did you, in fact, I mean, concurrently with this, because, look, you're depending upon the court to stay the order. If the court doesn't stay the order, we're shut down. So are you trying an interim emergency rule with, I mean, is that in the process? Because my understanding is DHS can come up with an interim emergency rule, could go into effect immediately upon publication that would reopen the process.
Again, we filed a motion last night to stay the proceeding, and we have made a commitment to an interim final rule to have in place by the end of April. We are working 24/7.
Why is it going to take a month and a half to do an interim final rule?
Congressman, this...
It'll be 2 months, actually, after March 4th. It'll be 2 months.
This program has been the subject of litigation since the Bush administration. To put a rule in place in a program that has had the complexity, this is a Lawyers Full Employment Act, the H-2B program. That's something I'm confident we can agree on. Every time we do something, whether it was the Bush administration, they got sued by someone, whether it's the Obama administration. One thing that's a constant in the H-2B context is litigation.
So you didn't see this shutdown coming? This potential court ruling, you really thought that since the court already ruled on the 2012 rule and invalidated it, the 2012 action, you didn't see this coming?
Well, we didn't think the court had the authority to do this. I've just outlined our plan, which is 8 weeks to put, or 6 weeks to put a interim final rule in a program of the complexity of this nature is is warp speed, I would say.
Mr. Secretary, and that's just because you just didn't think the court was going to rule the way it was. So there was no plan B in case that court issued that ruling.
Well, of course we have a plan B, and the plan B is we're doing an interim final rule because what we were doing up until the court ruled was we were working 24/7 to process all the applications, and that was the appropriate use of our resources. And when the court told us we no longer had the authority to process those applications, we immediately went to determine how can we get this program running as fast as possible.
And again, I just want to have one back to H2B, because H2B is so important in my district. Let me get the construct straight. I mean, DOL has twice now been rebuked by the courts, which have vacated their rules, the 2012 rule first, and then now 2008 rule, saying that DOL just doesn't have regulatory authority under the INA. So why doesn't DOL just say, okay, we'll go back to the pre-2008, where we merely consult and DHS is the primary, really the only rulemaker. Is that, that would solve the problem, wouldn't it?
There have been a number of decisions, including but not limited to the decisions that you referenced. And so, the courts have been all over the map on the issues of the H programs that we administer. The April 30th interim final regulation that I mentioned earlier will be a joint regulation of DHS and the Department of Labor, because each agency has equities, each agency has expertise, and that's why it will be joint.
Why should we believe that joint rule, that the courts wouldn't treat it the same way and say, look, DOL doesn't have regulatory authority? I mean, why not just come up with...
The current rule was a DOL rule. The IFR will be a DHS-DOL joint rule. The decision from the court was that you should do it together. We are doing exactly what the court told us to do. So in the end of April, it will be a joint rule. And I am confident that the issue that was addressed by the court will be addressed in our rulemaking.
Okay, and let me just ask just one final question. It's pretty brief. Why, when this ruling came out, did the DOL instruct the state workforce agencies to stop accepting H-2B job orders? I don't quite understand, because that would just have returned it to the the court ruling was the 2008 rule is vacated. To me, that returns it to the pre-2008 status temporarily, because the 2008 rule doesn't exist. And the state workforce agencies were empowered before 2008 to actually publish the H-2B job orders. Why would the department go out of their way to tell state workforce, specifically to employers, do not post H-2B job orders?
When a court tells you you don't have rulemaking authority, then you don't go around what a court says. And when you have, and the identical question was asked before, and let me tell you what I told the Congressman, which was, we cannot process them for the H-2B purposes, but they can still post the job to hire U.S. workers. So that is part of the H-2B requirement, is that you have to post the job. So anyone who's going through this process as we speak can still post job openings for H-2B workers. And
okay, that's not what the DOL communication to the state workforce agency reads. It says you can no longer accept or process such job orders in the H-2B program for the purposes of complying with H-2B recruitment requirements. So I don't know, maybe there's a disconnect in what they think the department has said. But I don't want to get to the red light. Thank you very much, Mr. Chairman. I learn.